Department of Safety and Homeland Security versus Eric Gordon.
Just a second. We'll give everybody time to get settled. You can stand there. You don't have to go back. I just don't want you to start until everybody's situated.
Your Honors, I'd like to reserve 2 minutes.
2 minutes. You may proceed.
May it please the Court, I'm Jeannie Weitzel from the Attorney General's Office. I'm here today representing the Department of Safety and Homeland Security, the appellant in this case. The Department respectfully requests the Court to reverse the Chancery Court's decision and affirm the Tennessee Board of Appeals' decision upholding the termination of petitioner appellee Eric Gordon's employment by the Department. This is a case brought pursuant to the TEAM Act. Petitioner was terminated for cause, and he challenged his for-cause termination under TCA 830-318, which is a provision of the TEAM Act governing the appeal process. Under the TEAM Act, the appealing party has the burden of proof at the Step 3 hearing before the Board of Appeals. It's in petitioner alleged in his complaint that he was wrong, he alleged in his complaint that the department wrongfully applied the disciplinary rules and policies that were cited in his termination letter. So at the Step 3 hearing, it was petitioner, as the appealing party, it was his burden to prove that the department had lacked cause and had wrongfully applied those policies and rules. At the conclusion of the hearing, the board upheld the petitioner's termination. The board concluded petitioner had failed to carry his burden of proof. They also concluded that the department did have cause to terminate petitioner. This court reviews the board's decision under the narrow standard set forth in TCA 45322, and the state's primary
Let me interrupt you
here,
just a minute. Are we reviewing the board's decision in the Step 3 appeal, or are we reviewing the chancellor's decision?
Well, Your Honor, we are appealing that, but you are to review the board's decision under the same standard of review. So yes, you are reviewing the board's decision.
What do we do with the chancellor's decision?
You would reverse that because it did not review the case appropriately under 45322, which is part of my argument.
Okay.
And the state's primary argument is the board properly upheld the petitioner's termination, and the decision should be affirmed because none of the grounds under 45322 is present here. Foremost, the board's decision that the petitioner did not carry his burden of proof is supported by substantial material evidence. I'll just talk briefly about the facts. Petitioner, on January 17th, 2020, petitioner attended a training class on the use of, to become certified on 2 different breathalyzer machines. There were 3 others in the class. The class was taught by the TBA agent and responsible for the eastern region of Tennessee, certifying machines and certifying officers to use those machines. As part of the class, the volunteers voluntarily submitted breath samples into the machines that they were training on. Petitioner blew a positive test. The agent requested he blow into another machine. He blew another positive test. The other individuals in the class, plus the agent, did not produce a positive reading. The department subsequently conducted an investigation. During this investigation, petitioner admitted he had consumed several alcoholic beverages the night before, gone to bed because he was to report to duty at 7 a.m. He went to bed around midnight. Sometime between 2 and 4, he drank an undetermined amount of straight vodka. And he woke up late and with a splitting headache, which he still had when he arrived late to the class. The investigators also interviewed the TBI agent, who stated both breathalyzer machines were operating properly and providing accurate tests. Based on this incident, the department terminated petitioner's employment for cause, citing multiple grounds in his termination notice. The
So
dismissal-
why was he terminated?
Why was he terminated? He was terminated.
Specifically, why was he terminated?
He was terminated for cause. Yes, I will get into it, but the breathalyzer test instigated the investigation, but it was his behavior of drinking the straight alcohol so soon before he was to report to duty.
But if he hadn't blown the numbers on the breathalyzer, I think the record pretty much shows none of what he had done the night before would have come to light, because he wasn't displaying any symptoms of intoxication. So really, we're sort of getting down to whether you can use a breathalyzer test that hasn't been through the calibrations that would make it admissible in a court proceeding. Can we use that to terminate? Is that not the heart of what we're asking here?
Your Honor, well, I think the heart of it is those are the facts that I've stated, and that's what the department based its decision on.
So, again, back to my question. Why was he terminated? What specifically did the board say he did that he shouldn't have done that required termination?
Well, Your Honor, I'll stay here. Petitioner, I'll start off. Petitioner relies on a case, Dixon v. City of Memphis, and the state submits that petitioner's reliance on that case is misplaced. I'll go back. At the Step 3 hearing, his main aim at the Step 3 hearing was to discredit these breathalyzer tests. We say, the Dixon case is distinguishable because in that case, the city had the burden of proof to prove that the policies had been violated. And in that case, they were not able to do so. On judicial review, that was a positive drug test, and that was only one policy that he had violated. And on review, they said it was improperly admitted. But that was the sole basis, so there was no material evidence.
Well, let me try it a different way then.
Okay.
Is it your belief or is it your position that the board or the trial court could consider the breathalyzer test?
Your Honor, yes. Our position is they could consider it.
For what purpose?
As that would be part to go, you've got to consider his own admissions and statements. Because if you look at...
We're conflating things here, and I'm trying to bring a little clarity to this. What purpose can either the board or the trial court consider the breathalyzer test for? Is it substantive proof of his intoxication? Can you consider it for that? Or is it just part of the chain of causation that gets you to where you ultimately come out? Or is there some other reasoning here?
Well, Your Honor, the reading wasn't important. They used it to the extent that it did just for the purpose of showing that it blowed a positive result.
I don't think I'm making myself clear, and I apologize for that. We know because of the admissions, or I assume we know, based upon the record I've seen thus far, there's no question that the appellee had been using intoxicants the night before. He admitted to that. He admitted to drinking. We know that. So how then does this breathalyzer test factor into that? We know he's consumed alcohol.
The breathalyzer test just corroborated what they learned from his admissions, his own statements. And that behavior...
What's the need to corroborate that? Nobody's contesting that.
Well, it's one more piece of evidence to show that his conduct violated the policies.
That's what I'm trying to get at.
Okay.
You say his conduct violated the policies. That was my original question. What was he terminated for? How did his conduct violate the policies, and what policies were violated?
Well, Your Honor, I will just give, for example, one of them was neglect of duty, and that includes engaging in any activity which would cause, it doesn't say it did cause, which would cause the employee to be inattentive to duty or which would impair the employee's ability to perform the duty. Code of Conduct Standard 2, a use of an alcoholic beverage or being under the influence of alcohol while on duty or immediately prior to reporting for duty is strictly prohibited. General Order 216-2, it talks about while off duty, no drinking that results in impairment to render the employee unfit to report for the employee's next regular tour of duty. And the Tennessee Highway Patrol officers who testified regarding the department's decision were based on these policies and others. I'm just highlighting. But the tenor was that petitioner, he made the wrong decision by drinking the alcohol so soon before he was report for duty, and he used bad judgment reporting to duty. He acknowledged that he thought about calling in sick because he felt so bad. And when you look at the testimony of Captain Street looked at that, looking at those policies, he was unfit to report to duty.
Well, did he admit that he felt bad because of the alcohol, or was there some other reasoning involved there?
Well, Your Honor, during the investigation, he said the hangover was a result from drink. I mean, he said the headache was like a hangover headache, the result from drinking. At the trial, at the hearing, he was more focused on what they were trying to say, is that it should not have been admissible, and he was trying to say to discredit it. The only other thing they did, it is the state's position that it was admissible, but so it was his burden to show that maybe they were incorrect, and he had some chewing tobacco in his mouth, but the state rebutted that with a TBI officer who said that that would not produce a positive effect. And petitioner did not bring any kind of expert witness to challenge the machine's accuracy or anything. But in sum, I would say we've got to look at the burden was on him to prove that he was wrongly terminated, to show that the department lacked cause. But if you look at the evidence and the witnesses, the department has the discretion as an employer. They looked at this as favoring poorly on the department, and it ruined his credibility and his credibility.
You've used your time. Thank you.
Thank you, Your Honors.
May it please the court. Good afternoon. My name is Bryce McKenzie. Mr. Delius and myself have had the pleasure of representing Mr. Gordon since 2020 in this matter. We're asking for this court to affirm the decision of Chancellor Jenkins in this matter and to re-enlist Mr. Gordon into the service of the Highway Patrol and pay back pay as ordered by the Chancery Court in this issue. I believe this court has been very astute in pointing out the primary issue on this matter. Mr. Gordon was fired. He was fired for cause, and the reason he was fired for cause were the results of breathalyzer tests, which are inadmissible under rules of evidence, which are inadmissible under statutory rules, and which are inadmissible under the department's own regulations.
Let me ask you a question, but in conjunction with that, I want you to answer Judge Davis's question, her initial question that she posed to opposing counsel as well. But my first question is, how do we know, based upon this record, what role the breathalyzer test played in the decision of the board, whose decision I assume we're reviewing?
The board, in its order, specifically listed the amounts, the measurements in making those findings. As a matter of fact, I believe it shows that the board in their determination didn't understand the evidence because they improperly found in that order that both machines were calibrated, which was not true. Agent Ferguson testified that the ECIR2 was not calibrated. So I believe we know that they relied on those two tests as a result of the order that they preponderated, or that they set forth after the hearing in this matter. Now, note it was not a unanimous opinion. There was a dissenting member of the panel. However, in that order, it specifically sets forth those tests and the amount in those tests as reasons for the firing of Mr. Gordon.
So you're taking issue with the initial decision of the board?
Yes. Yes, Your Honor.
Okay. And besides the breathalyzer test, or your perceived belief of their reliance on the breathalyzer test, what else do you take issue with the board's decision?
The board's decision discounted both Trooper Lawson, who was the sergeant on duty that was there during the training in January of 2020. Trooper Lawson specifically testified that he engaged with Mr. Gordon when he came to the training. He specifically stated that he had conversations and observed him, and that he had, quote, zero reason to believe that Mr. Gordon was impaired. And this is important because Trooper Lawson is an A-RIDE, DRE, certified trooper. He's been through the top percentile of law enforcement academies on how to detect alcohol use and drug use, which makes him a better witness than the state relies so often on Trooper Street and other people who are administrative in the administration of the Highway Patrol, not actual present witnesses. So we have a sergeant that was above him that testifies about his 15 years of stellar service, no issues with him, stating zero chance that he's intoxicated. The other thing that was ignored was their own special agent, Dave Ferguson. His main job for the Tennessee Bureau of Investigation is to calibrate these machines and to teach how to utilize these machines. And he specifically stated that when Mr. Gordon got to the training, he picked up on a conversation he'd had several weeks ago where they were specifically discussing the dissipation rates of alcohol in the bloodstream, and that he was engaged, that he was talking to him closely, and he saw zero evidence of any form of impairment and didn't believe that he was under the influence of alcohol. As a matter of fact, during the hearing, he stated that the results of the machine ran contrary to Agent Ferguson's personal observations. And there was nothing in the decision of the board that took into account that information, which is information that affirmatively shows that Mr. Gordon was not under the influence of alcohol in January of 2020. The order that was submitted from the chancellor specifically pointed out what his duty was to do as a reviewing court. And that was to determine whether or not there had been a violation of the rights of the petitioner, Mr. Gordon. And one of the reasons that that can be made is if there is a determination that's not supported by substantial and material evidence. The chancellor went through the facts, looked at this evidence that was introduced at hearing that showed that Mr. Gordon was not impaired, and decided that once setting aside these breath test results, which were in violation of evidentiary and statutory law, that there was no substantial material evidence that supported the board's decision. And that was the right conclusion. Because not only did this violate State v. Sensing, the well-established Supreme Court precedents regarding what has to happen in order for an officer to introduce a breath test and the 6 steps he has to follow. Specific statutes address these issues. In Tennessee Code Annotated 24-7-124B, it specifically states that if to be used in either a judicial proceeding or to be used in an administrative hearing, the officer's got to be qualified on the machine. There were no qualified officers taking these machine tests. Under TCA 38-6-103G, the TBI has to certify the machines in order for them to be admissible in a judicial or a, quote, quasi-judicial proceeding. Agent Ferguson testified that that ECIR2 was not calibrated. So in order for the state to prove their case, they specifically violated Mr. Gordon's rights by using evidence that was improper to introduce statutorily. And when that evidence is taken from the record, when it's stricken, what we have left are the people at the scene saying that Mr. Gordon did not impaired or intoxicated. Mr. Gordon did testify that he had a rough night the night before, and what the record's going to ferret out, it's because he's a war veteran. It's because he served in Iraq. He has a Bronze Star, and he had an episode the night before where he was dealing with a memory from the same gunfight in which he received that commendation. It caused him not to be able to sleep, and it was difficult for him to deal with. And he was quite candid about that. But he was clear in the hearing that he did not believe that he was impaired or that he drank in excess. He was clear during the hearing on that. And that's, his statements are supported by Sergeant Lawson and Special Agent Ferguson. When the state talks about Mr. Street and other troopers, the ones that weren't there, that talk about how Mr. Gordon's credibility is ruined, based upon what? I was there during that trial. Mr. Delius was asking Captain Street, who'd you talk to about Mr. Gordon's credibility? Did you reach out to General Jimmy Dunn, who prosecutes about half of his cases? What about these other cases where troopers had misconduct that had been reported in the news, where you didn't fire those troopers? And those are set forth in the record. I won't bring those up specifically in this. But those witnesses that the state's so ready to rely on in firing Mr. Gordon had no indication of what happened on that day, and they were not there on that day. So I believe, Judge, that you're correct. This is about those tests because those tests were the sole things relied upon in order for the state to dismiss Eric Gordon from his 15 years as a trooper. there's not any more questions, I'd like a moment to consult with my law partner and see if I've missed anything. When we talk about credibility in this case, the credible witness is Sergeant Lawson. The credible witness is Agent Ferguson, who states specifically what they observed. Absent that, there would not have been any reason to dismiss Mr. Gordon. And the official test that they did at LabCorp after the training came back negative, which is important to note. That is the Department of Safety test that they're permitted under 216 and 220 of their general orders. And they took Mr. Gordon to LabCorp, and that came back negative. And when we compare that to the credibility of the captains involved that we've asked that say that Mr. Gordon's credibility shot, but couldn't even name a single judge in the districts he practiced in where that would be relevant. We believe Chancellor Jenkins got this right, and we ask for an affirmance of his decision overturning the Board of Appeals.
Your Honors, just briefly, opposing counsel, again, he said, went back to the board, and he said the state had to prove the case. That was not the issue here. It was Mr. Gordon's burden to prove they lacked cause. And, Your Honor, I gave examples of some of those cited. I mean, none of them say, talk about the under the influence is only defined in one place, but just applying it all over. The employee is affected by alcohol in any detectable manner. It was within those, within the supervisors who run the entire Tennessee Highway Patrol, within their discretion, that looking at the totality of the circumstances, just as Colonel Stewart did, Colonel Stewart said he did not live up to the high standards we expect. He made a bad mistake by drinking straight alcohol so soon before he was to report for duty, and then he used poor judgment. And both of those are very important, and that plays into many of those, many of the rules and policies that were cited. And the blood alcohol test, they weren't used for the purpose of showing what the reading was. It just was one of the reasons that led to the termination. Everyone else was zero. And Agent Ferguson said, I've done 350 of these classes. No one's ever blown. And I think the board, just looking at the circumstances, they could see when he drank it, he felt horrible, and no one else had. And they get as decision makers, they can look in circumstantial evidence to determine that conduct did violate those rules and policies. And as Captain Street testified,
You've used your time.
Credibility, yes, it's within the courts. Have I gone over?
Yeah.
Oh, Your
Thank you.
Thank you.
Thank you, counsel. We appreciate your briefs. We will take that and your oral argument into consideration, as well as the evidence and record, and we'll attempt to get you an opinion at the earliest possible time. You may be excused. Thank you.